Jeff, welcome to the show.
Thank you for having me. Really excited.
Thank you for flying out. You came a long way.
I did. Flew out from Miami, South Florida, where I'm born and raised, and happy to be in Los Angeles right now.
Well, we'd love to have you. And so normally what I do is I have you introduce yourself. You're very accomplished. You're a tremendous lawyer, but I'm going to give you the lead oar on this, and you make the introduction.
Okay. Well, I will try to do my best. So I'm originally from South Florida, born and raised, and ended up going to school at University of Michigan for undergraduate, and then ultimately Ohio State for law school. I know that Michigan and Ohio State are two rival schools, so for me it was kind of the best of both worlds, kind of going and being acceptable fans of like the Yankees and the Red Sox simultaneous. So that was kind of nice, and then decided that I wanted to get out of the cold and be back in South Florida, and worked my way through various law firms, insurance defense practice area, commercial litigation. Worked on one of the largest Ponzi scheme litigation cases in United States history, and ultimately became a partner at one of the 7 largest law firms in all of the United States, and in fact, I think one of the largest in California. And since then became a partner here at LS Carlson Law, and now I'm the managing partner of the Florida office. So it's very exciting times.
Well, we're very fortunate to have someone like you, your leadership. You've done tremendous things in Florida. And today's topic, Florida is a hotbed. This is a topic which is a hotbed topic in South Florida, particular, or I guess all of Florida, which is really HOA and condo law, Homeowner Association law, Condo Association law. The disputes are tremendous. You see a lot of disputes happening because you have a very high density. So I think Florida lends itself to this, and your team, you guys have really become thought leaders in Florida. You are the go-to firm when it comes to homeowner representation. So I think it's wonderful to have you on the show and really discuss this topic of an HOA or COA dispute. Best practices, what does it look like? And so I guess I'll lay the foundation. I'll make it relatively simple, but you have a homeowner. They have a dispute with their HOA. Let's say it's a negligence case, failure to maintain a common area. What does that homeowner do, right? There's a lot of options, and I think a lot of homeowners really don't understand the law in this area because it is somewhat convoluted, but they also, I really don't think that they understand the amount of protections they have as a homeowner or as a landowner, right, if they own a condo. So that's where I want to start.
Yeah, so first and foremost, Florida is a hotbed for a lot of concerns that people have with regards to their HOAs or condo associations. A lot of it really became focused on when about 2 years ago, the tragic events of what happened in Surfside, Florida, where we all saw the Champlain Tower South collapse. And it's really disappointing and sad on so many different levels. I think from a association perspective, it really had people wake up and understand that they need to know about their associations. They need to know the infrastructure of what's going on, not only from an outside and concrete and brick and mortar perspective, but on the infrastructure on the inside, and knowing what their rights are and knowing what a board does to help facilitate living in a condo or an HOA so that a property owner can use and enjoy the place that they bought, the place that they own.
I really like that point because I think there's a misconception when someone goes on the board. It's not just a club to hang out with your buddies and drink by the poolside. Right? I mean, there's a fiduciary obligation that they're taking on. There's a contractual obligation that they're taking on. And really those legal expectations are there to maintain property values and protect the people in the community.
Absolutely. And a lot of people are starting to know, and I hope learn more often and more frequently, that they do have so many rights that they don't realize, and powers that they can use. For an issue of where an association is not maintaining, repairing, or replacing various common elements within its association, and a property owner has certain rights to make sure that the association is doing what they're supposed to be doing legally. And one of the first things that I would always suggest is get information, because information is power, especially in an association context. The good news is that in terms of how Florida works, a property owner or condo owner can literally request and see and access information that the association is required to provide, required to show, so that a condo owner who is concerned, a homeowner who is concerned that certain things are not being done with the money that they're paying, whether it's a monthly, quarterly, or yearly basis, they need to know where their funds are going. Because a lot of people say, hey, I'm paying money so I can pay off the property manager.
Right.
Or pay money so that it goes to a vendor, a landscaper, whomever. But at the end of the day, what you need to know legally is that money is your contractual responsibility based on an inherent contract that you signed with your association when you bought the property to begin with. And not many people understand that. They say, oh, well, I entered into a purchase agreement with the former owner. Well, you not only did that, but you entered into a contract in a deed-restricted community. And your obligation is to make those payments. The association's general obligation in return for your payments is to uniformly and equally enforce your governing documents, your condo docs, your association documents. And a lot of those provisions in your governing documents are things that you need to know about, especially if you believe that the association is not doing what it should be doing, especially with maintaining its common element area.
Well, you raise a good point about this notion to access to documents. And typically when a case hits your desk, and I think you'd agree with this, the fact pattern is the homeowner, the landowner, has reached out to the HOA, reached out to the board, has requested those documents, and has really just gotten stonewalled, whether it's from the management side or the board side. And so from a legal perspective, that's sort of your opening move, correct, is to procure that information, that evidence, which is really so powerful.
So, yeah, you once again, in getting the information, getting the access you need to understand what is going on and what rights you have is paramount in this situation. And if you are getting stonewalled based on certain requests that you make, whether it's requests to see documents, requests to have them answer questions, in some cases, you do have rights in that respect to enforce and push an association to comply with their failure to enforce your rights to accessing certain records, which are called in Florida official records, which are generally any written records that relate to the operation of your association. Yeah,
and in my mind, if you are being stonewalled, I mean, that's really the first red flag. If they're refusing to disclose, for me, that's really problematic. I mean, there's immediate a lack of transparency, but then it goes to what are they hiding? What do they not want the homeowner to see?
Well, in that instance, you would think that if they had nothing to hide, that they would just show the ball, show everything that you need to in that respect. And ultimately, the association should show you documents that they're legally required to maintain. And if they don't, the good news is, at least from a Florida law perspective, that a property owner does have certain rights to escalate and certain rights to utilize against an association to say, hey, look, you're not giving me the information not only that I need, but that you're required and legally obligated to show me. And as a result, I can try to escalate it. I can even try to fine you based on certain tactics if you choose to use them. And there have even been recent lawsuits in Florida in which this type of dispute of accessing official records has become a very pointed subject, especially on the topic that associations are very fearful to reveal certain disclosures of information, certain financial records, In fact, some people don't even realize this, but you're even entitled as a condo owner to email communications between a property manager and a board member, so long as those emails relate to the operation of the association. And a lot of smoking gun information comes from that alone. And associations are very careful to not want to give access to that information that you're legally required to see.
Well, the other strategy I like and that your team does very well, in that opening move for the request of documentation, you often also put a demand for preservation of evidence, because the immediate concern is, oh my God, they're going to delete all the emails.
Yeah, so one of the first things we do, really within 48 hours of having someone wanting to enforce their rights, is we'll let them know that there is a letter that's coming down the association's pike. And that letter is going to say three things. First, it's going to notify them on our letterhead that this person has retained us to enforce their legal rights. And the association's probably going to Google us. They're probably going to Google me. They're going to know that I'm not this client's brother, sister's trust attorney. They're going to know that I'm literally doing nothing but representing property owners. The second thing that letter is going to say is that it's going to demand to preserve evidence, like you just said. And that demand is very critical to making sure the association understands that if they don't preserve evidence, if they don't keep information that we know that they knew they had and discarded it, that would open up a legal can of worms of something called spoliation of evidence, which ultimately would create more legal exposure for an association. So we want them to know that we know that they better not throw anything away. And then the third and final thing we do in that letter is we demand that the association give our clients access to these records that they want to specifically request. And the good news is this type of letter, this type of right, the law explicitly says that the association would have 10 business days from the day they receive that letter to not just respond, but to give my client access to those records. So I like to say that in legal time, it's a very efficient right. It should give you the answers that you need in a very timely way. And it's a very powerful tool to know if your association's hiding anything or if they're willing to show you things that they should have shown you to begin with.
Yeah, I mean, it's a tremendous opening. As you know, I play a lot of chess, right? And chess theory often dictates that you take command of the board, the middle of the board. And with one letter, you really do that. You're putting them on their heels. You're demanding that all communication goes to you. So no longer can the HOA, let's say, harass the client.
Correct.
It's the demand for preservation of evidence. They now know we cannot delete any of the emails because you can find that out in today's modern society. It's easy to track down electronically whether something's been destroyed. But now they have a legal obligation to respond. I mean, that's right out of the gate. You're taking control of the dispute.
Oh, absolutely. And you're taking control of this dispute, but you're more importantly enforcing your statutory rights. A lot of people think when you send a letter like that, or you're trying to enforce your right to get access to records, or something called a written inquiry, which is basically a fancy phrase for a written question that needs to be answered. Ultimately, you're not bringing a lawsuit. You're not doing anything in the public domain. You're simply utilizing a right that every property owner in Florida is given. And not many people, some people are afraid or fearful, hey, am I going to poke the bear? Am I going to, wake a sleeping giant if I do this? Well, the good news is you got to realize that they've already shown you that they have a strategic advantage, or make you think they have a strategic advantage because you're thinking that way.
Right.
And ultimately what we want to do is make sure that our clients know that we're not, poking a bear or waking a sleeping giant. You're making sure that you are imposing your rights, and it's essentially a checks and balances, if you will. You both have equal footing. You both have similar obligations within the governing documents. and let's put our cards on the table and say who is and who is not complying with your own rules of the road within your governing documents. That's what this is all about.
So that's the opening move. But let me backtrack a little bit. When you're assessing an HOA dispute, really, I would say you have three plays. You have a simple demand, not this opening demand letter, but a more substantive demand letter identifying the dispute. So I would consider that more of a IDR, informal dispute resolution play. Then you have what we consider an ADR demand, or a demand for mediation, and then you have litigation. So I would argue that typically when you're a homeowner, you're sort of vetting those three options. Could you sort of walk everyone through those three options and sort of identify what is typically your play? Not always. I mean, it's not always going to be the same, but...
Right. So every case is different, right? And every case requires different strategy. Every case requires certain legal analysis to see what rights or what tools are the best tools to use based on your legal claims and how to appropriately enforce them, right? So usually you're right. There comes a time when you get certain information, get certain records where there's kind of three paths generally, and you said them: litigation, informal litigation, or a mediation or arbitration demand letter. I refer to as an ADR demand letter. ADR is just an acronym for Alternative Dispute Resolution. And so in terms of litigation, you got to know that if you're jumping into that immediately, you're ready for battle. You understand the causes of action against your association. You believe that they've forced your hand to do this, and you're simply wanting to make it very well known in a court of law that this can't go unappreciated, and a judge and or a jury need to figure out how to appropriately resolve this issue. Usually with litigation, I will tell you that I always want to make sure that the client makes a fully informed decision of what they're getting into, if that's their first choice.
Because it's a big step, it's a big commitment once you sort of turn on the litigation machinery.
Yeah, a lot of law firms, a lot of people that, lawyers don't really go through the pros and cons of filing a lawsuit first. I always want to make sure that a client is fully advised of the pros and cons. For example, a very strong benefit of filing a lawsuit immediately is to make sure that everybody knows that this association's not doing what's right.
Because it's public. It becomes public record.
It becomes public record, and I will tell you, especially in Florida, association legal disputes have gotten a lot of media attention, okay? So that's a definite benefit, and maybe that is used as leverage to resolve it so it doesn't escalate further. Right. But then there are some negatives, and I always want to make sure that, for that strategy decision, you got to know that a lawsuit can be very expensive.
Right.
And, and just because you pay money doesn't guarantee you're going to win anything. Any attorney that guarantees victory is lying and not being ethical.
Right.
And so that's first thing. Second thing is that you have to understand that lawsuits can be very time consuming. In a court of law, depending on a judge or a jury, it can take a year, 2 years, 3 years, sometimes even longer. And so you got to know that it takes two to tango in that respect, and if you're willing to go to battle, you got to know that in advance. It could take that long.
Yeah, I'm glad you bring that up because, well, first, right out of the gate, I think there's two things that you're analyzing. It's the legal analysis, right? Do they have the viable causes of action? Can we ethically bring the lawsuit? But there's the economic edge of it as well, because it can get very expensive, and it's a very big commitment right out of the gate.
Absolutely. And you're looking in terms of fees. Every dispute's different, right? And you don't know how an association and any other defendant is going to approach your lawsuit. But I usually like to say that, it can be, tens of thousands of dollars, if not hundreds of thousands of dollars. Right. Once again, no guarantee of victory. Just because you're paying this money doesn't mean you're going to absolutely win. And then there's the component from a financial perspective of, usually what's called prevailing party fees. Prevailing party fees, the best way to say that is the legal winner fees. And if you're the legal winner and you're entitled to prevailing party fees, then the good news is the other side, the losing party, would have to pay all of your reasonable fees. However, it works both ways, because if there is this prevailing party fee and you just so happen to lose in your case, then not only did you have to pay the attorney's fees on your side, but now all of a sudden the other side would be entitled to their reasonable fees as well. So sometimes can be high risk, high reward, but in that respect, you've got to at least know that is something to be aware of eventually as a lawsuit grows and evolves. And then there's this third component, which I think gets lost in all of this with most lawyers, because lawyers by trade just know how to litigate cases, go to courthouses, take discovery. There's an emotional aspect to it. And sometimes, depending on the dispute, your emotions might, be an important aspect of whether you can go through the lawsuit in its entirety.
Because it's very taxing. It's a very taxing process, not only on you, the individual or the plaintiff, but family members, people around you. I mean, it's a drain.
I mean, that's the thing. You live in this community. It's not just you slipped and fell at a local grocery store and you don't go to the grocery store again until your case is resolved. No, you have to live in this community. You have to drive by your neighbors every single day. You don't know what they're thinking about you. You don't know, if there's going to be, a lack of communication, a lack of community, because you're simply trying to enforce your rights. It's a major problem that you have to think about, at least when you choose litigation as your first choice.
Well, given that's the framework, I suppose what's really nice, and you can speak to this, is that's not the only option, right? There's another play that can be made before jumping into or pressing the nuclear option.
And you said it best. The good news is I always like to say avoid litigation until it's absolutely necessary. Because otherwise you got to know that there could be unintended consequences, even though you feel very passionately about not only your rights but enforcing those rights. And so there are these other options that you can do in a less public way, and more time-efficient way. One of those options is to go through an informal demand letter process, or an IDR. And one of the things what we would like to do there is just let the association know, hey, association, there are some legal issues going on. We'd like to resolve them in a setting that doesn't open Pandora's box.
Right.
And let's see if we can make sure that our stars align, because association, my client's not going anywhere, you're not going anywhere. It makes no sense to escalate if we can try to avoid that. And let's see if we can resolve our differences just between us. And there's good and bad to that as well.
Because I think in the ideal world, you would always go with a demand letter if they were effective. But, and I think you would agree with this, you could see that how the other side can take advantage of it because it's informal, it's a demand letter. It doesn't carry the legal weight necessarily as some of the other options.
Correct. So in terms of trying to informally resolve this, there's not much of a legal mechanism or a legal carrot, if you will,
right,
to try to force them to talk with you. There's no obligation for them to do so, but most people want to say, hey, look, I want to try to resolve this with you. You're clearly not maintaining common elements. You're clearly not providing me access to official records. There's clearly mismanagement issues. There's clearly lack of communication issues. Let's try to work this out.
Right.
And you would think that in that type of setting, there would be a mutual interest to try to resolve it. And I do think that in a lot of occasions, it is a very helpful strategy because at the end of the day, why escalate it if it's it can be avoided.
If reasonable minds can come together and negotiate it fairly, then that's a different story.
Absolutely. When reasonable minds, but the trick word there is reasonable.
Right.
And so, maybe the association is entrenched in its position, and maybe they do believe they're, spending money appropriately on certain things. And what we see a lot of times as a kind of a fallback argument that they say is, hey, who are you to tell us as a board how to use association dues? Or there's something called a business judgment rule, at least in Florida, where as long as the association feels like what they're doing is in the best interest or best judgment of the association, it can make its decision appropriately. The problem with that is when it turns out that information, official records, responses show that the decision, it was completely outrageous, completely egregious. And in a lot of situations, we find that lack of transparency ultimately will reveal a conflict of interest, or funds going, funneling to some person or some vendor that just happens to be so related to a board member.
Right.
And there are certain rules and restrictions about that. And so those are the types of things that we would try to want to resolve before it goes out into the public domain. Because at the end of the day, both sides want this community flourishing, want it to grow, want high property values, so that everybody wins. And you would think that both sides would want that, but it's not always the case.
Well, especially if you have that self-dealing element, right? They want to hide it from the public. They don't want it to get out. They don't really have a reason to be reasonable because what they're doing is unreasonable. So with respect to the IDR, what we've seen is it sort of becomes this informal dispute resolution loop. It goes nowhere. There's a lot of back and forth. The client is paying a lot of money, but it doesn't really have an end sort of game to it, right? There's no finality to it, which kind of backs us into this notion of the ADR play, which is interesting.
Well, and the problem sometimes with IDR is that there's no obligation to respond.
Right.
They
can just ignore the letter.
They can literally take the letter, put it in their file, and close the door.
Right.
And throw the key away. So ultimately, what you can do if you don't want to escalate it to in the public domain, and you don't think that your association is simply going to,
be reasonable
and try to, have differences just align organically. What do you do? And I kind of feel like that third option is probably the best legal tool that property owners have prior to escalating it in a public domain, which is your pre-litigation right to what's called alternative dispute resolution, this ADR component.
Right.
And there you have a pre-litigation right that it does have a legal stick behind it. And ultimately, it's a demand letter. It's a standard demand letter, except in Florida, it's a statutory demand letter. And it makes it that much more legally important for the association to do something. Ultimately, what this demand letter does is it explains that a person would have a legal dispute with the association. And it would lay out the legal dispute, explain, the facts involved, perhaps the law involved. We usually like to be very comprehensive and include aggressively case law that stands behind those certain claims, attach exhibits to those claims to make sure that the other side knows we're not just making accusations, we're backing it up.
Well, they're well-founded, they're supported, and they've been researched and investigated, right? I mean, I think that sends a huge message to the other side that you're just not slapping together a bunch of allegations, but it's a comprehensive demand saying we investigated this is the evidence we've been able to gather. This is now the other side sees that they have a problem.
Well, ultimately, at the end of the day, we want the ideal way that we like to prepare these types of ADR demand letters is to be out in front,
right,
and let the association know that we've got enough information to try to escalate this. but we don't want to right now. We want cooler heads to prevail. We want to try to make sure that any type of arrangement is done within a community setting. Keep it within the organization. Right. And I think it's an appropriate, prudent, strategic letter for the association to know, especially know that a client knows his or her or their rights. And ultimately what this letter does is it forces the association to make a really tough decision. The decision that they have to make, they really have 3 doors to walk through. Okay, the first door they would have to do is, within a certain time period, agree to the demands made in the letter.
Right.
Okay. So that's door number 1. Door number 2 is they would, in lieu or instead of agreeing to the demands within that same period, they would have to agree to an arbitration or a mediation. Okay. And a mediation and an arbitration are very different, and I can get into that in a moment. And then door number 3 is agree to neither door number 1 or door number 2. But if they agree to door number 3, they're effectively daring the person to file a lawsuit.
Right.
And in that instance, if a lawsuit's filed, that would trigger certain prevailing party fees if my client was to win in the lawsuit. More importantly, the law for both a homeowner or a condo owner in Florida says that if the association chooses door number 3, my client files a lawsuit, and just so happens that the association wins in your lawsuit, then the statute does not and prohibits any prevailing party fees, attorney winning fees for the association.
And that's a big gamble, huge gamble.
It's a big gamble for the association because the statutes specifically say that they waive all of their rights to prevailing party fees because it could have all have been avoided perhaps if they simply at least agreed to a mediation.
Well, that goes to the policy, right? They're trying to avoid jamming up the courts with these disputes. They're trying to encourage them to reasonably sit down with a third party neutral to get it resolved before escalating to litigation.
Right, and that's one of the reasons why in Florida they've even required mediation happen or be offered first before a lawsuit. And mediations are usually, or generally speaking, a understanding or idea that I like better than anything else. Because with mediations, you do have a third-party neutral. Usually it's a former judge or somebody who really knows and understands law or has encountered these similar situation before. And a mediator's role is not to be a judge, not to decide a winner or a loser. He or she's role is to simply see if the parties can align. Parties can, kind of have a kumbaya. And ultimately, the goal would be for the parties to not necessarily capitulate or not necessarily, conversely just stand their ground, but see if there is a common goal here and try to understand if there is a creative way to resolve their differences.
Right.
And so I usually like mediation a whole lot more, especially in association-related disputes, because at the end of the day, it's a way to try to avoid any escalation in a legal setting with a neutral person in a confidential way to try to get these issues resolved.
Yeah, it's sort of that middle ground because, with litigation, that's obviously, as we discussed, a huge step. IDR it's interesting if they're reasonable, but in these scenarios, it's unlikely that they're unreasonable because you're there in the first place. The ADR is sort of that middle ground where you're putting a hypothetical weapon on the table, but very nicely saying, I think at this point we should discuss this. Because if it doesn't go well, okay, you still have litigation in your back pocket.
Absolutely. There's a lot of advantages that provide leverage during an actual mediation. One of the most important things is you are showing the association that you're willing to come to the table now, but ultimately if you don't want to resolve, if you basically attend the mediation and that's it, or you don't ultimately see eye to eye on a property owner's claims, then you've got to know and expect that a lawsuit could be coming your way.
Right. It's not just it's a threat that's really materializing because the client now is going through the process. They're checking the boxes. They're gearing up for it. Hopefully it doesn't come to it, but everyone knows that it is a very viable threat at that point.
Very viable, and especially the concern would be if the association shows up without insurance coverage, because there's a strategic advantage in knowing if an association has protected itself through its own, commercial general liability insurance policy or a directors and officers liability insurance policy. Because if there isn't a policy that's been triggered and there's no insurance defense lawyer representing the association during the mediation, then it shows you as a property owner that they have not submitted your demand letter to be a covered insurance claim. So that also means that there might not be a deep pocket necessarily, but it would mean that you would have a strategic advantage in knowing that they don't believe that you will escalate it. And if they believe that, you better be sure that you strike the fear in them to make sure that it could happen, and maybe they might be more willing to give you information or meet you at some of your most important demands. If they do have insurance covered and insurance defense at the mediation, there is good news and bad news to that too, though. The good news is now you know that you would have potentially a deep pocket or a decision maker to provide monies. But sometimes these disputes aren't necessarily about money.
Right. You're looking at somewhat intangibles or even specific performance, right?
Correct. And so sometimes if you're looking for an association to make repairs or allow you to build something on your exterior of your home, having an insurance defense lawyer being covered by insurance defense is not going to help you. Right. Because what you're really wanting is not money-based, non-monetary based. And so sometimes the concern is an association might be willing to just throw money at the problem, but not ultimately wanting to deal with the perhaps more important issue, which is, hey, fix the common areas. Right. And so that is sometimes very telling in knowing prior to the mediation how the association is approaching your demand letter, even though they agreed to a mediation. And all of these things we use as information and leverage to ultimately try to get the dispute resolved and get the client as much as the client not only deserves but wants. And so ultimately the hope is that both parties can see eye to eye and resolve their differences so that each party can move on in their respective ways. All
right, let's break it down mechanically because, let's go through sort of the flow of this because, you're retained, viable dispute, and let's assume you've identified ADR as the best course of action. You said within 48 hours you're getting out the notice of representation, the demand for preservation of evidence. What does the following flow look like? Just from a mechanical standpoint, what can a potential client or an individual expect to see moving forward?
Yeah, so one of the first things we want to do is get as much information from a client that they already have and use that to start the basis of figuring out from a legal due diligence perspective how we can establish their claim if they have one. And what I like to do is make sure that I understand from day one a client's end goal, because I kind of feel like we can't know where we're going until we know.
You got to identify the target.
Exactly. And so we try to find that out by seeking precise information from then the association. The hope is that the association understands our clients' rights and therefore gives us access to the information we would need to basically put the pieces of the puzzle together. Right. And once we do that, we're able to do what we like to call a preliminary analysis to make sure that the client knows that we're going and vetting the legal side of things and putting all the law and the facts kind of in a blender, so to speak. And not going to show you how what the blender, what other ingredients the blender includes, but ultimately you've got to know that when we're done, we know what claims will succeed or would most likely succeed at a mediation for leverage or through an arbitration process, what arguments an arbitrator might think is convincing, and ultimately let the client know, probably within a few weeks' time, that they have a good faith legal claim, or there are certain things that we need more information about, or quite frankly, we've run every analysis through our system and we just can't find something that's of good faith. Usually we will do whatever we can to find the arguments that we can make, but sometimes there are anticipated defenses, and at least we let the clients know, hey, we have a good faith argument here, but you got to anticipate this defense is coming. But the good news is we're going to be able to preempt that legal defense or factual defense.
Yeah, you're kind of going behind the curtain, as you know, in terms of how your team works and how lawyers work. But really what you're getting at is laying the terrain first, understanding the terrain both from a factual perspective and a legal perspective. But once you understand that terrain very well, you're able to very confidently proceed with the ADR demand. You know what's coming down the pipeline. You have a pretty good understanding of what the other side may or may not do.
I think what a lot of people don't understand about being a lawyer is that a lawyer is not necessarily just a cheerleader. A lawyer is there to be objective. A lawyer is there to, hear and understand what you're going through in the sense that that person is having some difficulties that need expertise or help of somebody who's gone through these battles, who's gone down the rabbit hole before. And unfortunately, sometimes down that rabbit hole are things that you don't like and things you don't want to see. So not only is it a cheerleader's role, but also to tell you the truth, to be upfront. And a lot of lawyers are afraid to say those things. And we like to say them pretty quickly and out front so that our client can know going forward what things they should expect to hear, what arguments they expect to know in advance. But the good news is about that, we're already prepared and trained and experienced to know what those arguments are.
Right.
So we'll be able to be prepared to knock those issues down and use those anticipated defenses as a way to legally get to where our client wants to go, which is get their goals, whether they're non-monetary in nature, monetary in nature, or maybe a combination of the two.
Well, yeah, I think what you're getting at too is you like this.
I can hear you better now.
Like this.
Yeah.
Closer. You don't want to lead a client off the cliff. That's ultimately what you're getting at. And the initial due diligence, the work that you perform up front, you can identify causes of action where it may not be as viable as it may appear at first glance. But once you get under the hood, you understand the terrain very well, you can say, hey, we can push this argument, but here are some of the pitfalls. And I think that's very powerful for the client to understand that.
Yeah, absolutely. And sometimes it takes a little bit longer than how clients want, but the way we like to do it is we like to do it the right way the first time.
Right.
And so when we go through that process, and we'll let the client know, hey, these are the things that are going to work. These are the things that are not going to work. But ultimately, the things that might not work, we're going to use to our advantage in a different way. Yep. And when we finish that analysis, what we end up doing is recommending that we think that your dispute could be either prime for a lawsuit or litigation, for informal dispute resolution, IDR, or this ADR, alternative dispute resolution demand letter. And that's when the client wants to eventually makes the decision, his or herself or theirselves, of which route they want to go. And ultimately, depending on which route they choose, especially based on our recommendation, they'll be the coach and we'll be the quarterback.
Right. Well, let's follow the ADR play, because I see that it's very common, and I mean that in a good way. I think it's a great way to resolve disputes. So now you're past the due diligence phase. the client signed off on the ADR demand strategy. You've now prepared the ADR demand. What happens then?
When you prepare the ADR demand letter, ultimately the way we like to do it is, at the end of the day, it's our client's claims. We're just their vessel.
Right.
And so we want to make sure that we get the client's input before any formal letter gets sent out like that. So we'll make sure that it gets sent to the client, they review it, they understand it. Sometimes the client wants a less aggressive tone. Sometimes the client wants more aggressive tone. It really depends on, how the client wants it to be prepared, because they know ultimately it's going to be sent to their association,
right.
Not mine, not yours. And so we want to do it in a way that makes them feel good about it.
Well, I think tone is everything, right? It's so critical. I mean, you can get the law right, you can get the facts right, but how do you convey the message?
Absolutely. And sometimes, there's strategic and creative ways you can use words to your advantage, and that's what we do as lawyers.
You're wordsmiths.
Absolutely. And so even though I don't know if wordsmith is actually a word, but
I've heard that is not a word.
Yeah. So, but ultimately, in the sense that we want to be persuasive, but we want to be precise, because one of the ways that we like to do it is make sure that the association understands the gravity of the decision now they're going to have to make. And ultimately, if they receive this letter, this demand letter, this ADR demand letter.
Yeah, once you throw the grenade into their camp, what do you see? What can you expect?
So in that period, in terms of Florida, the association has 20 days. They have 20 days to make the decision to walk through open one of those three doors.
Right.
And at that point in time, there's a lot that is uncertain, because we don't know how an association is going to act. Sometimes an association won't respond until day 19 or day 20. Sometimes they'll respond immediately. But ultimately, if the association doesn't respond at all within that 20-day period, there could be those legal consequences that we talked about earlier, which was basically be a door number 3 decision. And so usually that period of 20 days is really a period of unknown. And because we just don't know how the association is going to act. Sometimes what does happen is we kind of get a little snapshot of what they might be talking about, because during that time they'll announce that there's a closed board meeting, and usually the lawyer's invited to that. And so our guess usually, and it's a pretty calculated one, is that they're probably going to be talking about your ADR.
It's a good bet.
Letter.
Yeah.
Yeah. So that waiting process can be frustrating, but ultimately whenever the association does make a decision, and they can go a variety of routes, we would know exactly how to proceed based on whatever decision they make, because we are putting the ball in their court.
So in this hypothetical, let's assume that they respond favorably, they accept the mediation. What does that look like at that point?
So, and favorably can also mean that they accept some of your demands too.
So it could almost be a hybrid response.
Cool.
Yes, we'll capitulate to items 1 through 3. The remainder, we'd like to mediate.
Absolutely. That's the optimal decision that we get. But if they agree to a mediation, it depends at that point what mediator they would want to use, because the way that we send out our demand letters, our ADR demand letters, is that we propose 5 different mediators. And these are all mediators that are neutral and certified appropriately. But ultimately, these mediators are mediators that the association would have to agree to at least one. And if they agree to at least one and only one, then that's the mediator who we're going to go with.
Okay.
If they choose more than one of our 5 that we've proposed, then the good news is, let's say they choose 3 of the 5 that we proposed.
Okay.
The way the law is set up is our client, would be the one who makes the final decision amongst those 3.
Got it.
And sometimes it's a matter of what our client prefers, whether, sometimes the hourly rate, sometimes the the time requirement. Sometimes some mediators prefer in person versus in a Zoom mediation now. So there's a lot of thought that goes into ultimately which 5 are proposed and which one is ultimately decided on. And at that point in time, once a mediator is decided upon, the mediation would have to immediately be scheduled, and the mediation has to occur within 90 days of the date of the actual letter, unless the parties agree otherwise. So really, you're looking from a legal standpoint at a very quick process. So if you're anticipating that a lawsuit can take a year, 2 years, 3 years, sometimes even more, a mediation process can take 3 months or less.
Right, and I think that goes back to what we were saying earlier about the IDR. The IDR doesn't have any of those timelines embedded, right? There's no legal stick, so to speak, to move the case forward. And in theory, it could get into some back and forth that is sort of endless. Versus ADR, upon acceptance, upon sending the letter, really, there is a timeline ticking on the other side.
Absolutely. The IDR process, there's no obligation for an association to respond, to do anything whatsoever. It's simply a device that can be used to try to resolve, depending on if you think the association would be willing to resolve it in a very quick and efficient way. And that's why the ADR demand letter is a pretty strong tool that property owners can utilize, because it does force the association to make a decision to appreciate your demands, appreciate your legal disputes, and if they agree to a mediation, they are going to hear you out. They are going to be able to hear your opening statement. Usually I give the opening statements.
You have a unique way of presenting the case at mediation. I don't think all attorneys do this, but I think it's so powerful and impactful. Do you want to speak to that, the PowerPoint presentation that you guys utilize?
Yeah, so we've found, especially since COVID has showed that mediators prefer Zoom mediations now. It's a very visual medium, and Zoom, there are people like it, people don't like it, but it's not going anywhere.
Right.
And so one of the things that we like to do is use Zoom and use this visual medium to our strategic advantage. And one of the things that we like to do, we found being very successful, is creating a PowerPoint presentation that ultimately is shared on the Zoom screen. And we use it to, in concert or at the same time I'm giving my opening statement, to visually show the other side what we're talking about.
Right.
Because sometimes what happens is our ADR demand letters, they can be very lengthy. And to a normal person, they can be very boring.
Right.
Maybe not to the association's attorney, because the association's attorney would see the legal strengths of our claims. But at the end of the day, the decision's not being made by an attorney. It's being made by a board member, property manager, insurance adjuster. So what we like to do is show them visually what the dispute is really about.
And I would say often with HOA disputes, there are a lot of visual elements to the dispute, right? It's some sort of impact to the property, or it's failure to maintain a common area. We can talk about it, we can use words, but when you show a picture of a home that's been impacted, let's say by water damage, that is so impactful.
Oh, and these types of disputes for sure lend themselves very well to photographs, visual aids. You're right, water damage photo, a camera being shown directly into our client's property, uneven steps or uneven sidewalks. We're talking about photos of financial records,
right?
Emails, correspondence sent between our client and the property manager, our client and board members, to show the harassment, the targeting. And so these are all important things, depending on the situation, to show that this is evidence, or this could be evidence.
Right.
This could be brought into a court of law, or if at the very least, I'm going to be asking you about it when you have to swear under oath within a court reporter's testimony, court reporter to type everything down, and guess what? That's eventually going to turn into perhaps public record. So you better be prepared to know that these are the things that we're going to utilize and show you now, so we can show you in a confidential setting that these are the things that are eventually going to be disclosed if we're not going to be able to resolve here today at the mediation.
Yeah, so I think the PowerPoint is tremendously powerful and impactful, and especially, but that visual comes into play at the actual mediation. We were talking earlier today about another tool that you sometimes use even before the mediation, so that when you show up to the mediation, the mediator has a really strong grasp legally and factually of what's going on. So I like to differentiate it between a cold opening mediation and a warm opening.
So I think I understand what you're saying. So there are certain things you can do to make the neutral mediator understand your claims before the mediation, okay? One of the things that we like to do during the mediation is show a PowerPoint presentation. However, one thing that we have found very effective is we let the mediator know in advance, in a confidential way, just between us and the mediator, not the other side, that we are very confident in our claims, and here's what the dispute is really about, and here are the arguments, here's the exposure the association has, here's probably what they're going to say, but know that these are the things that I might not say during opening statement, but you got to know in advance, mediator, that if they say these things that they really don't have much merit.
Right.
And this hopefully gives the mediator enough information in advance of the mediation to fully absorb what the dispute is about, to fully appreciate my client's concerns, and to then he or she fully recognize that these concerns have merit.
Right.
And at the end of the day, a mediation, I could say, give the best opening statement I've ever given. And the association's attorney can give the best opening statement he or she has ever given. But the most important part of the mediation is the mediator. And I always like to make sure that our clients know that the mediator needs to be neutral, but you need to show the mediator enough so the mediator invests in you.
Right.
Invest in you as a person, invest in you in your claims, invest in you in your rights. Because, a mediator's role is to try to get both sides to come together, but there's not going to be any movement during a mediation unless the mediator triggers that side.
Right.
And so we want to try to, prior to the mediation and during the actual mediation, let the mediator know that we have a strong position factually, legally, practically, so that at the end of the day, the mediator goes into the other room wearing our client's hat and says, hey, look, you guys need to understand that there's a lot of issues that you need to talk to yourself about, because I've read and learned about this dispute, and you need to make some decisions at this point.
And that document, just to clarify, that's the confidential mediation brief, which is submitted to the mediator before the actual mediation occurs.
Correct. So that's one of the things that I was referring to in terms of informing the mediator prior to the mediation. We draft this document called a mediation brief that eventually lays out all of what we believe the dispute is about, what our arguments are, what our clients' demands are, where we are in any type of settlement communications prior to the mediation, and what their anticipated arguments are, and what you should know about those anticipated arguments.
And that's kind of what I was getting at in terms of the warm opening, right? It's not the mediator coming in for the first time and seeing a PowerPoint. The foundation has been laid. The mediator knows what to look for, and then the PowerPoint becomes just a huge exclamation point on sort of what they already know or what they understand to be the case.
Yeah, and the mediator is, his or her job is to make sure that the mediation goes as well as it can, because this might be the only opportunity both sides have to speak to one another before an escalated lawsuit happens, before it gets into the public domain,
right,
before insurance has to be involved, before the entire community hears what's going on, before potential buyers in this community know what is going on. So there are a lot of ramifications of what could or couldn't happen if a mediation doesn't result in some sort of settlement agreement. So that puts a lot of pressure on the mediator to try to resolve these things, but ultimately we want to do whatever we can to help facilitate the mediator and his or her job to try to get the parties to see eye to eye.
All right. Well, I think this is a good point to segue into just the nature of mediation, right? Mediation, for a lot of people, I think they understand it in concept generally, but if you could go through sort of what the mediation format is, and then give me your insight into the pros and cons of mediation.
So in terms of how a mediation generally works, it's a private setting where the client or the property owner is there and their attorney, the association and their attorney is there, and then there's this mediator. We don't know in advance who is going to show up exactly on the association side.
And sorry, just to clarify one point, because that could scare a lot of people. People are showing up, but they're not all in one room. Typically, they're separated. They don't necessarily see each other face to face.
So in the way that Zoom mediations or even in-person mediations work in Florida, everybody is in the same room at once. However, the good news is what we try to do is we try to let our clients know in advance of what they should expect or what they should do prior or in the moment of the main room mediation. So this lobby area is where everybody sees each other. But the good news is nobody has to say anything beyond just pleasantries, morning or afternoon pleasantries, because at the end of the day, the first person to speak is going to be the mediator. The mediator is going to lay out the ground rules. The mediator is probably going to give his or her resume and basically make sure both parties know that this mediator is a person of authority, that this mediator doesn't have decision-making authority, but the mediator is very well aware, has experience, whether he or she's a former judge or has this experience to try to resolve the dispute between the parties. So the mediator, while uncomfortable for others in this main room, seeing everybody for the first time, the mediator usually takes the microphone and says what needs to be said from the outset to keep the train on the tracks from the first moment everybody's in the room.
So point of clarification, though, there are situations where the parties are very hostile. There's a lot of acrimony between the parties, and that environment, maybe a client just is so uncomfortable that they refuse that sort of format. There are special requests that you can make to the mediator to bifurcate. No? Have you done that before? Have you ever been in a situation where that's arisen?
It's never happened to me. It's been a request made, but I would always, even if our client is tentative to see eye to eye or see them in the face, I always want at least the mediation to start in a main room.
And then they go to their separate rooms? Or
Yeah. So the way it works that I prefer, or I would usually recommend to a client, is even if you have such disgust for someone on the other side, I want you to get your voice heard to them. I want them to see your dispute. I want them to see your evidence. I want them to see that you have real, legitimate legal claims. And I know that those people are probably going to hear things they don't like about your claims. They're probably going to be upset about them. And at the end of the day, you are getting your voice heard for them. Now, once the opening statement on your behalf is done, then they're going to say something. And I can guarantee you, especially if there is animosity, we prepare our clients all the time to make sure they know that they're not going to hear things they like.
Right.
That they might, we've had situations where the attorney attacks them as a person and their credibility. We've had attorneys just make outright lies made and known for the main purpose of irritating our client, for the
Right.
main purpose of what I refer to as the bright, shiny defense, where they're trying to make you not see where your claims are and instead pointing to something else. Happens all the time. And we know ultimately where those defenses lie and what arguments are to be made, and that's why we do whatever we can to prepare our clients.
Which sort of goes back to that due diligence period where you know the terrain, you can anticipate what they're likely going to say. So when the client does show up, it's not a shock. It's not out of left field.
No, absolutely not. I always tell my clients two things. We always like to be 3 steps ahead, and I always want my clients to be over-prepared.
Got it.
Because if we are always thinking 3 steps ahead and if we're always over-prepared, they never have to worry about a thing. And I feel that when we make sure of that, when they are fully informed, when they are over-prepared, when we do things 3 steps ahead, we always come out on top for our clients.
So going back to that initial question then, what would you say if you can isolate your top 3 or 4 pros of mediation and the top 3 to 4 cons, downside of mediation?
Okay, so in terms of pros of mediation, I always like that the parties are trying to do what they can to resolve it in a confidential way. I always believe that, especially in association disputes, these people have to see each other after the mediation. They have to probably interact with one another. They have to interact with each other's friends in the building. So I always like that component of it. Another thing I like about mediation is time. Usually mediations are a half day or a full day in length. And so if you're going to try to get this issue resolved, instead of wasting or using or going through 1 year, 2 years, 3 years of a lawsuit, you can hopefully get this resolved in 1 day's time. And then the third thing I really like about it is the emotional aspect of it, where the client has probably lost a lot of sleep for days, weeks, months, if not years, over this exact issue, this exact concern. And this is the moment where, yes, they would have to make very difficult decisions in real time. But ultimately, if they make decisions where both sides eventually see eye to eye, and there is this ability for both sides to tango or dance on the same dance floor, then ultimately they can be put to bed. Our clients can get the resolve they want and hopefully get better sleep at the end of the day. And they most importantly, use the property that they bought to begin with in a way that they anticipated they would enjoy.
Right.
It. In terms of 3 things that I don't like about mediations.
Yeah.
First thing I don't like about mediations is sometimes mediations can escalate issues. Sometimes attorneys try to intentionally rattle our clients by saying things that are either untrue or don't matter or are personally attacking and offending. And they only usually say those things because they might not have the position that they want.
Right.
And ultimately that can get a client's move a client's eye off the ball of ultimately why they're there to begin with. And I don't like sometimes the inappropriate maneuvers that are said and done and made during a mediation. Second thing I don't like about it is mediation is inherently confidential, but sometimes it just so happens that things are said after the mediation by the other side, and to enforce the confidentiality rights is a whole another issue.
Right. It becomes a separate breach. It becomes a separate dispute unto itself.
Correct. And so unfortunately, whoever spilled the beans, so to speak, didn't either grasp the advice of his or her counsel or just didn't care. And unfortunately, that's creating exposure for the association. But the whole inherent point of mediation is to speak freely, so that their confidentiality is so strong.
Right, to help facilitate the process.
Exactly. And then in terms of final things is, in terms of a mediation, sometimes it's a half day or a full day, but sometimes there's just not enough time in the day to get a written settlement agreement, which is the end goal. To
right.
have both sides align, understand the terms of what each side wants to do and agree to. And sometimes people say, hey, I only have so much time to do it. And they don't want to strike while the iron's hot. We'll say, hey, look, we've agreed to these terms.
Let's sleep on it. Let's come back to it tomorrow.
And it happens almost every single time. There's Monday morning quarterbacking. And if a deal is not signed by both parties in the same day of the mediation, every day that goes by after that, I'm less hopeful and optimistic that a deal will actually be done. Because until there's signatures on the agreement, there is no agreement. They did not agree to give you everything they said in the mediation. And most people think, hey, they agreed to it then, they're going to agree to it down the road. That's not always the case.
Right. Well, Jeff, thank you. That was very informative and thoughtful. I mean, you've gone through the process. I mean, if anyone can speak to this, it's you, and you're doing tremendous work. So thank you, and thank you for being on the show.
Thank you. I really just hope that people appreciate their rights, know what they are, learn what they are, because at the end of the day, we want to do everything we can to tear down this preconceived notion that an association is the bear.
Right.
And we want to make sure that they know that we're trying to level the playing field for them. And we think it's not only leveling the playing field, but really trying to show the association that they're not all that they're cracked up to be.
Well, you're doing marvelous work. So thank you, and your team are just exceptional.
Thank you very much. Glad to be here. Thank you for having me.
Yeah, anytime.